Network. This is MorningLine.
Good morning, everyone. Thanks for joining us on MorningLine. Nick Beres here on a Tuesday, and I am glad you are with us. We're going to take your phone calls this morning. I hope you join in the conversation because we're going to be talking about the very, very busy time we've had following what's going on with the U.S. Supreme Court. And unless you've been living under a rock over the past week and a half or so, you're probably well aware of many of the high-profile case decisions they've come down with, many of them with direct connections here to the state of Tennessee. But there are some lesser decisions as well, lesser in terms of publicity that they've received that we'll talk about this morning. But we're going to get into all of that. I want to take your phone calls on your thoughts on some of these decisions that the court reached. But more importantly, we'll talk about it and get some, I think, feedback from our guest this morning who really, it's basically his living following this type of stuff as a professor over at Vanderbilt University, Professor James Blumstein. Nice to have you on, sir.
Nice to be here.
It's a pleasure having you on. And I know I just get the sense that this has been, was it riveting for you last week? Were you enthralled by it? I mean, you've told me you think this is just a very, very important milestone week for the Supreme Court.
It has been very significant. The court has heard some important cases earlier on, but typically they reach agreement on the most high visibility cases towards the end of the term, and they did finish the term on schedule, which is yesterday, and then they were off to the various places, taking a big sigh of relief. Although I did see just last night that they had weighed in on an abortion case, granted a stay of the application of the Texas law that would have effect on certain abortion clinics, and so they've put that on hold until they can either decide to hear the appeal or not. So they're not going to be shying away from important issues next time. They also granted review in a case called Fisher versus the University of Texas. This case had been the way a court decides to hear a case is it goes to what they call the conference of the justices, and only the justices are there. Their law clerks are not. No one is there but the justices themselves. And this case had been up for consideration for 5 or 6 times before they finally agreed to hear it, called Fisher against Texas. They've heard it once before, and it involves racial preference in admissions at the University of Texas. So that's going to be on the docket again next fall.
They don't meet again until the fall, correct?
October.
October. Well, Professor Blumstein, let's talk about some of the cases here. You know, the big ones that a lot of people have paid attention to. Can we start off, do you mind, with the same-sex marriage decision?
Sure, absolutely.
First of all, I mean, close, the way it played out, but in your mind, was there some surprise for you, or?
Well, not so much surprise with the outcome. I think that this was, many of us saw the handwriting on the wall. Justice Kennedy, who's the swing vote on these issues, seemed at oral argument not to be fully convinced. But by the time he wrote the opinion, and the way it works at the court is that the senior justice who's in the majority gets to assign the opinion. So that was Justice Kennedy, and he assigned the opinion to himself, not surprisingly. What was surprising was the far-reaching language, rhetoric, some would say, in the opinion itself. It was, it focused very much historically, recognized that same-sex marriage was a new phenomenon, but that the institution of marriage was central to our heritage, and that access to it should be afforded to those of the same gender, same sex. Very sweeping. And the analysis, the court attempted to put some analysis, but it broke some ground. There's nothing about marriage or same-sex or even heterosexual marriage in the Constitution directly. The terms are due process and equal protection, which are very open-textured terms. And the 14th Amendment says no state shall deprive any person of life, liberty, or property without due process. And the court said that marriage was a fundamental liberty, and fundamental becomes important because that means the government cannot tinker with a fundamental liberty except under extraordinary circumstances. And where did it get this from? Well, looked at historically at things like contraception among married couples. Now, of course, that was a right that was expanded to non-married couples as well. And so the court looked historically and said, yes, same-sex marriage is new, but many of the values of marriage are transcendent and really don't depend upon the sexual characteristics of the participants.
Now, let me ask you this. People, whether they agree or disagree with this, are going to wonder now with this ruling, how might it affect their day-to-day lives? And I think for many of us, it won't. But on the other hand, some of the emails I received in blogs and contacts through my Facebook page say, all right, so does this mean someone now has to be forced to perform a marriage for a gay or lesbian couple? Where does that come down?
Yeah, the two frontier issues now, the two are, and some of the dissenters raise this, is whether or not in some faith traditions, for example in Islam, what's called polyamory, multiple wives for men, or in fact sometimes polyamory could be more gender neutral, where there's more than two people in a relationship. We can expect to see those cases being brought. Whether they will succeed or not is a different question. But I think that will be the next frontier. Are there limiting principles? The court went out of its way to say a relationship is a union between two people, but once the court says that it's a fundamental interest in marriage, why would a Muslim who has a different faith tradition or a historical member of the Church of Latter-day Saints, a Mormon, why would those folks who have legitimate, sincere faith traditions be deprived of an institution that has this historical importance that the court talks about? Now, there may be distinctions, and the court may be able to draw those distinctions, but those will be issues that will be raised, I think. I predict.
Meaning where they would go after a religion?
No, they would say a three-person marriage would claim that they have the right to be married, and that the notion that this is limited to two people does not withstand scrutiny any more than a man and a woman stand scrutiny. So, so that's the question. And at oral argument, interesting, Justice Alito asked this question. He said, "What if not three people, but four people came into the courthouse and said, we want to have four people as our family?" Are there good criteria that would allow the court to draw a distinction? Now, I think there may be, but it would depend a little on what the evidence is on its effectiveness on child rearing, for example. But if the evidence suggested that four people as a group could, takes a family, that they could raise children effectively and well, the court will have to really search hard to see what the distinctions are. And there may be some. I'm not saying there aren't, but that's going to be the next frontier for litigation.
So what would happen if someone tomorrow showed up, four people, to get married?
Right now, the law would not recognize it, but then they would
they would challenge it
and bring a suit based upon this case. And I think the court would have to take it seriously and have to deal with it. The other frontier question, and I think this is the second one, is what about the faith traditions of those great faiths, Orthodox Jewry, for example, Catholic Church, that find same-sex weddings at odds with their religion.
Right.
And will they be forced to engage in marriage ceremonies that violate these religious precepts? Now, it's pretty clear that the Catholic Church, just to use an example, could get out of the business of performing marriages. The real issue is, will they be able to keep their tax-exempt status, or will this be deemed to be discriminatory? And the model is Bob Jones University many years ago, in the 1980s, 30 years ago. Bob Jones University had a religious precept against interracial dating, and they banned interracial dating on the campus. The government came in and said that's race discrimination, and that is at odds with your tax-exempt status, and they threatened to pull the tax-exempt status.
Meaning they're saying that you're a private university, you have a choice. If you want to do that, you're no longer going to get tax-exempt status.
Exactly. And that's the risk, is that if this is deemed discrimination, like race discrimination, and the Catholic Church, as an example, or an Orthodox Jewish synagogue, were to say, we're not going to perform these weddings, the question is whether they'd have to get out of the wedding performing business entirely, or whether that would be deemed discriminatory and put at risk their tax-exempt status. So I think that's the next issue that's going to come up. And interestingly, that was raised at oral argument, and the government's lawyer, the Solicitor General, Donald Verrilli, said to, I think it was Justice Alito, but to one of the justices, well, that issue will be faced, and he refused to say what the government's position was, suggesting that it was an open question whether churches will now have to, if they're going to perform weddings, will have to perform them on a non-discriminatory basis or put at risk their tax-exempt status. And the Bob Jones University precedent, which involves race discrimination, is the one that would be most analogous.
What did Jones, as we go to the break, do in that case? Did
I don't remember. They had a choice of either.
Did they give up their status, or did they change the policy?
Well, the university still exists, I guess, and I think that they gave up the policy, but I'm not sure. They had the choice. They either had to give up the policy or give up their tax-exempt status.
All right. We need to take a break on that note, Professor. When we come back, as you just heard listening to him, and it's fascinating, two elements. If you thought this was over, the same-sex marriage and the debate over various facets of it that come out of this decision, you're wrong. You're right. There's going to be more coming along that way. And I'd like to hear from you as well. You're going to talk about other cases, but I know this is a big one, a lot of people discussing. 737-7587. If you're on hold, stay there. Give us your take on the Supreme Court decision on same-sex marriage and more with the professor right after this.